In February of 2022, the Supreme Court issued a single-paragraph order with no signed opinion, and that order determined which congressional map Alabama would use in that year's elections. 16 months later, the same case, argued in full and decided on the merits, came out the opposite way. If you have heard people call this the most consequential shadow docket ruling in years, or heard other people call it a routine, legally unremarkable stay, you have heard two very different stories about the same sequence of events. Today we are going through exactly what happened, in order, with the actual vote counts, the actual language from the justices involved, and what happened when the case was finally argued and decided on the merits. You can draw your own conclusion about what it means. My job is just to get the sequence and the record straight. Before we get into the details, if legal explainers like this one, tracking exactly what courts actually said rather than how headlines summarized it, are useful to you, consider subscribing, because I break down cases like this regularly. Let me know in the comments after you hear the full sequence whether you think the court handled this the way it should have, because I think the facts here genuinely support more than one reasonable view, and I want to hear where you land once you have the whole picture. Let's start with the underlying dispute, because you need the facts on the ground before any of the legal maneuvering makes sense. After the 2020 census, the Alabama legislature redrew the state's congressional districts for its 7 seats in the United States House of Representatives. Black residents make up 27% of Alabama's population, but under the new map, they formed a majority in only one of the 7 districts, meaning black voters had a realistic chance of electing their preferred candidate in roughly 14% of the state's congressional seats, despite being more than a quarter of the population. A coalition of civil rights organizations and individual Alabama voters filed suit in November of 2021, arguing the map violated Section 2 of the Voting Rights Act, the federal law that bars election practices resulting in the denial or reduction of voting power based on race, as well as the 14th Amendment. The case went to a 3-judge federal district court panel in Alabama, the standard structure for certain voting rights and redistricting cases under federal law. That panel heard 7 days of testimony and reviewed more than 1,000 pages of briefing before issuing its ruling. The panel found that the plaintiffs were likely to succeed on their Section 2 claim, concluding that Alabama's map likely violated the Voting Rights Act under the legal framework the Supreme Court itself had established decades earlier in a 1986 case called Thornburg v. Jingles, which sets out a 3-part test for evaluating vote dilution claims. The district court ordered Alabama to draw a new map including a second district where black voters would form a majority, with a deadline of February 11, 2022, giving the state very little time before the upcoming election cycle. Alabama immediately asked the Supreme Court for an emergency stay of that order, seeking to pause the district court's ruling while the state pursued a full appeal. This is where the case entered what is commonly called the shadow docket, the Supreme Court's process for handling emergency applications outside its normal calendar of full briefing and oral argument. On February 7, 2022, the Supreme Court ruled on that emergency application, and the outcome was a 5-4 vote to grant Alabama's stay, meaning the district court's order was paused and the original contested map would be used for the 2022 elections after all. The 5 justices in the majority were Clarence Thomas, Samuel Alito, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett. The order itself was brief and unsigned, and it did not walk through detailed legal reasoning explaining exactly why the district court's findings were wrong. Along with granting the stay, the court also agreed to treat Alabama's application as a request for full review and granted certiorari, meaning it committed to hearing the case argued in full during its next term. Now here is where the internal disagreement on the court gets specific, and the details matter. Chief Justice John Roberts dissented from the decision to grant the stay, meaning he sided with the losing side on that particular vote, but he agreed with the rest of the court that the case should be taken up for full review. In his dissent, Roberts wrote that the district court, in his words, properly applied existing law in an extensive opinion with no apparent errors for our correction. That is a notable line because it means the Chief Justice was not arguing the lower court had gotten the law wrong. He was specifically objecting to using the emergency stay process to pause a ruling he believed had been carefully and correctly reasoned. Separately, Justice Elena Kagan wrote her own dissent, joined by Justices Stephen Breyer and Sonia Sotomayor, taking direct aim at the court's broader pattern of using emergency orders in cases like this one. Kagan wrote that the decision was, in her words, one more in a disconcertingly long line of cases in which this court uses its shadow docket to signal or make changes in the law without anything approaching full briefing and argument. Her dissent focused less on the specific facts of Alabama's map and more on the process itself, arguing that consequential rulings were increasingly happening without the transparency of a full written opinion. On the other side of that disagreement, Justice Kavanaugh, joined by Justice Alito, wrote a concurrence directly responding to Kagan's criticism. Kavanaugh's argument leaned on a legal principle from a 2006 case called Purcell v. Gonzalez, often called the Purcell Principle, which holds that federal courts generally should avoid changing election rules or procedures too close to an actual election out of concern for confusing voters, election officials, or both. Kavanaugh argued that with Alabama's primary election approaching in May, ordering a brand new congressional map on the district court's compressed timeline created exactly the kind of last-minute disruption Purcell was designed to prevent, and that the stay simply preserved the existing map until the case could be properly and fully resolved. The three other justices in the majority, Thomas, Alito, and Barrett, as it applied to the underlying order itself, did not write separately to explain their individual reasoning beyond joining the unsigned order. The practical result of that February ruling was straightforward. Alabama used its original contested congressional map for both the 2022 primary and general elections, meaning the map the district court had found likely violated the Voting Rights Act remained in effect for an entire election cycle, while the underlying legal question stayed unresolved. The case was formally renamed Allen v. Milligan after a change in who held the office of Alabama Secretary of State, and it was argued in full before the Supreme Court on October 4, 2022, with Alabama defending its map, the original plaintiffs and the NAACP Legal Defense Fund arguing against it, and the United States Solicitor General filing as amicus curiae in support of the challengers. On June 8, 2023, 16 months after the emergency stay, the Supreme Court issued its ruling on the actual merits of the case, and the outcome was different from what the shadow docket order alone might have suggested. The court affirmed the district court's original finding by a vote of 5-4, with Chief Justice Roberts writing the majority opinion, joined in full by Justices Sotomayor, Kagan, and Ketanji Brown Jackson, who had since joined the court and joined by Justice Kavanaugh except for one specific section of the opinion. The majority held that Alabama's map likely did violate Section 2 of the Voting Rights Act, reaffirming the same Thornburg v. Jingles framework the district court had applied from the beginning, and rejecting Alabama's broader argument that the court should substantially narrow how Section 2 vote dilution claims are evaluated going forward. Justice Kavanaugh's vote was widely described as a surprise by court watchers at the time, since he had joined the majority granting the stay back in February, but he ultimately provided the decisive fifth vote upholding the district court's original reasoning on the merits. Justice Thomas wrote a dissenting opinion, joined by Justice Gorsuch and, in part, by Justice Barrett and Justice Alito, arguing that the ruling would effectively force Alabama to draw districts aimed at achieving a level of proportional representation that Thomas argued Section 2 does not actually require, and that he suggested the Constitution might not even permit. Justice Alito wrote a separate dissent, also joined by Justice Gorsuch, focused more narrowly on how the majority applied the Jingles framework's specific evidentiary requirements. So here is the full arc laid out plainly. In February of 2022, a 5-justice majority paused a lower court ruling using the emergency stay process without a signed opinion explaining the legal reasoning behind that specific decision, and the paused map was used for an entire election cycle. In June of 2023, after full briefing and oral argument, a majority built from a different combination of justices, including one who had voted the other way at the earlier stage, affirmed that the original lower court ruling had been correct all along. Alabama was then required to draw a new map, though it is worth noting the state's first attempt at a revised map after the ruling still did not include the second black majority district the litigation had called for, leading to further proceedings before a court ultimately adopted a new map for the following election cycle. What you make of that sequence is genuinely a matter of interpretation, and reasonable people land in different places. Some people look at this timeline and see the shadow docket working exactly as designed, a temporary procedural pause preserving the status quo during an active election season, while the full case gets properly argued, consistent with a legal principle the court has applied in other election cases for years. Other people look at the same timeline and see a lower court's careful, well-reasoned findings, which even Chief Justice Roberts himself declined to dispute, effectively overridden for an entire election cycle by an unsigned order, only to be vindicated more than a year later once actual voters had already gone to the polls under the map the district court said was likely unlawful. Both of those readings are grounded in the same set of facts. Which one strikes you as more troubling or more defensible probably depends on how much weight you put on process versus outcome. And that is exactly the kind of judgment call I want to leave with you rather than make for you. If walking through the actual sequence, the real votes, and the real language from the opinions helped you form your own view instead of adopting someone else's headline, hit that like button so more people get the full picture instead of a slogan. Subscribe if you want more explainers that lay out exactly what the record shows before anyone tells you what to think about it. Drop a comment with your own read on this one, process concern, outcome vindicated, or somewhere in between, because I think this is one of those cases where the disagreement itself is worth sitting with rather than rushing past.